Hello and good morning. It is a beautiful, look at that sunrise. It is a beautiful morning here in sunny Sacramento, or thereabouts. And on this beautiful morning, I have had the opportunity to listen to Granite State just terribly, terribly misstate the law yet again. That was fun. She's got a privacy complaint from a lieutenant in the Department of Corrections for somewhere. I don't really know. And so she's saying that if they don't retract the complaint, or if YouTube takes action, she's going to file a suit. And believe this or not, I think that she would win if she filed suit. Now, I don't know if she'd make a whole ton of money if she actually stuck it through all the way till it ended. She'd probably get nominal damages, but of course, being a money hound, she'll probably settle well before then to save everybody attorney's fees and all that fun stuff. Auditors love to settle because that's money in their pocket instead of a judgment on the books. Judgments don't pay, money does, right? Anyway, so beyond that, I think there's a reasonable chance that she could win, you know, depending on the case law of that particular circuit. I have a feeling that a corrections officer acting in his private capacity trying to take down a video or censor a video of him while he was acting in his public capacity, I think that would still be state action. So I am about 80% confident that it would be a good, valid lawsuit with a chance at redress. You really just went around me for no reason? Ha! Know what? There you go. But beyond that, she starts citing Veritas. Well, she cites Glick. Glick is obviously good law. It's a Court of Appeals decision. It's binding. It's precedent on every district court in the First Circuit. But then she starts citing Veritas, and Veritas is not precedent. It is not binding on any other court in the First District. So it would be great if she actually remembered that. I think I said something about that in my analysis of it, where I stated specifically that don't get too excited about it. It is just a district court decision. And then she stretched the decision. I don't remember it saying anything about recording phone calls of public officials, but what I do remember of it is that it didn't bother to go in and define what public spaces were. It didn't define what exactly public officials are. So, because it was trying to interpret Glick. And the last thing it certainly did not do is it did not force public officials, government workers, to speak. If she calls on a recorded line, what prevents the government official from hanging up? The only thing that would prevent them from hanging up is if they have a policy that says they can't. But in this case, they have a policy that says they can. And even then, if they violate their policy, then they're just subject to internal discipline, like whatever their agency would do to them. It's nothing that you'll probably ever know about. So that's pretty retarded. They don't have to talk to you. And you can quote district court cases all day long, but it doesn't make you sound smart. It makes you sound like you missed your calling working at Dairy Queen. Speaking of stupid, D. Cup Jones is trying to raise money from stupid people. I mean, I bet you thought I was going to say that he was stupid, and he is, because he's trying to raise money from stupid people for stupid reasons. He needs $1,600, guys, to fly to Oklahoma to resolve this issue with News Now Bobby Hill. But News Now Bobby Hill is already out of jail. He bonded out. So why does D-Cup need to go there? D-Cup isn't a lawyer. And D-Cup did such a good job at Leon Valley, didn't he? I mean, everybody just pause the video right now and give D-Cup Jones a standing round of applause for his solid efforts and performance at Leon Valley, where he gassed out all the time, every time, and everybody in law enforcement completely disrespected the lying thief D-Cup Jones. He's got no pull. I mean, he's a retard, and he's just trying to convince other retards that he's important, and he's not. Suggesting that there be another mass audit in Oklahoma is also pretty retarded. I mean, it did work out so fantastically last time. Oh, but we might get a lawsuit. Oh, we might? Might we? What we are going to get is some precedent that cops can't arrest witnesses under Texas law, or maybe under any law. I mean, it might stretch out to just a blanket. It's a Fourth Amendment violation to seize a person without probable cause, period. And I think it should be. But hey, who am I to say? That's about the best we might get out of it, if it gets that far. If it stays in the district court, if the plaintiffs win at the district court, which I think they should, unless Radner screws it up, or unless the plaintiffs screw it up for themselves. But if they win at district court, which I think they should, then it's just going to be a district court decision. And again, it's going to be persuasive and not precedential. He's just eating. Let's see. When I watched the frogs video, I was unaware that Patrick was in Oklahoma. That's why I didn't make any reference to any states. I did not reference any state laws for any state because I didn't know where he was, and I just made a 1-minute video. But thank you for everybody who pointed out to me that he is in Oklahoma, and Oklahoma doesn't have a stop and ID statute. Thank you. I've only watched the frogs video. I don't much care to watch Patrick very often because he's annoying. But it would be interesting to know what happened prior to the clip that I watched from the frog. I've heard that the cop said trespass somewhere in some fashion. And if that is the case, if the cop was going to give a criminal trespass warning to News Now Bobby Hill, then Patrick would have to ID for that. Because at that point, basically what it's saying is we could have arrested you for criminal trespass, and we're going to make damn sure you don't do it again. So there's that. And then we have the library master, News Now Pizza Boy, who I shouldn't make fun of. I shouldn't mock his work. So News Now OKC, with his little rat tail, trying to tell us what qualified immunity is. Qualified immunity is designed to protect public officials, not just police officers, but government workers, government employees, people with discretionary power. It's designed to protect them from mistakes of law or mistakes of fact or mistakes of fact mixed with law. Where the auditards tend to get it wrong is the various cases will say that the officers or the government workers with discretionary power, they have to be put on notice before you can get past their qualified immunity. Because if you can't get past their qualified immunity, you can't sue them. And they have to be put on notice. And what does that mean? Well, News Now OKC read that, and I'm assuming he read that, or somebody told it to him. It was probably more likely because he audits libraries. He doesn't read at libraries. But by being put on notice, what they're saying is that they have to put on notice is generally when the court would put them on notice, where the court has made a ruling about a particular law. Now, as far as a particular fact is concerned, if it is a mistake of fact, the only cases I'm aware of where mistake of fact has been somehow dispositive is where, like, a clerk types in the wrong license plate number for a wanted person, and an officer pulls over a car matching that description based on the bolo of the clerk who entered that number in error, and ends up finding some contraband or something. He finds a crime, but it's the wrong car, but he finds a crime. And is that a Fourth Amendment violation? Absolutely. The cop didn't have probable cause to pull him over. There was a mistake of fact. So should the officer be sued for it? Well, the courts have a two-prong analysis. And basically, if there is no malice involved, it's basically like, I'm paraphrasing here, so I don't remember it off the top of my head, but it's basically like, is it kind of a reasonable mistake? And is it something that suing them can deter from happening again without chilling their ability to use the discretion that they need to use? We don't want people with discretion to be frozen in fear of being sued every time they make a decision one way or another. Now, what I have never seen, and I would love it if somebody could point it out to me, is a case where a suspect stated something as a fact to the officer, and the officer chose not to believe the suspect, and then that was enough. It put the officer on notice as far as the mistake of fact was concerned, enough to get past qualified immunity. I don't think it ever will. The officer is not going to believe the suspect, just not going to believe him. There is no requirement that the officer believe the suspect. Imagine if that were. I mean, obviously, News Now OKC can't imagine it because he's not that bright. But for those of you who can imagine it, imagine every time an officer interacts with a suspect, the suspect is going to say, "I didn't do anything." Well, if News Now OKC's interpretation was correct, then all of a sudden the officer would have to be like, well, I guess if I continue on and they actually didn't do anything, then I'm liable. My qualified immunity is gone. And it would stop officers from basically being able to arrest anybody, because everybody would simply say, "I didn't do anything, officer." Is that a baggie of cocaine? No, officer, it's baking soda. Well, I gotta believe him, because even though it looks like cocaine to me, even though this guy has a history of being a cocaine dealer, if it is just a bag of baking soda that he's going to use to cut a later batch of cocaine, I'm screwed, because I don't have probable cause at this point, and my qualified immunity is gone, and it's an awful, oh no, I'm going to lose my house. We don't want that. Well, I'm sure some auditors do, because some auditors just hate the police just in general, and they don't understand that police are necessary to a functioning society. I guess that's about all for today. I thank you all for watching my little ramblings while amblins. Please understand that I know I probably got that two-prong test for qualified immunity wrong, but let's see if you could do it off the top of your head without researching anything. At least I remember it's a 2-prong test, and I hope to God I'm not wrong about that, or else I'll really feel silly. Pretty sure it's a 2-part test. Anyway, I'll look it up and I'll do a video on it later today, I guess. Anyway, just thank you all for watching, and have a great day. Oh, it's the poop of shame.